Hello and welcome to the Minimum Competence episode for Thursday, April 23rd, 2026. I'm your host for today, Andrew Leahy, an assistant teaching professor of law at Drexel Klein School of Law. On today's episode, AI copyright battles, a new joint employer rule proposal, and a Supreme Court fight over FCC fines and jury trial rights. Let's remember, endurance is not just the ability to bear a hard thing, but to turn it into glory. And read today's legal news. On this day in legal history, April 23, 1969, Sirhan Sirhan was formally sentenced to death for the assassination of Robert F. Kennedy, a crime that had shaken the United States the previous year. The sentencing came after a highly publicized trial in Los Angeles where prosecutors argued that the killing was deliberate and politically motivated. Evidence presented at trial included eyewitness accounts placing Sirhan at the scene and actively firing the fatal shots. His own recorded statements, which expressed hostility toward Kennedy, played a key role in establishing intent. The defense raised questions about Sirhan's mental state, but these arguments did not overcome the prosecution's narrative of premeditation. The jury ultimately found him guilty of first-degree murder, leading to the imposition of the death penalty under California law at the time. The sentence reflected both the gravity of the crime and the broader national trauma surrounding political assassinations in the 1960s. However, the legal status of capital punishment in California soon shifted dramatically. In 1972, the California Supreme Court decided People v. Anderson, which held that the death penalty as then applied violated the state constitution. As a result, Sirhan's sentence was commuted to life imprisonment, aligning his case with others affected by the ruling. The Sirhan case remains significant in legal history for its intersection with issues of political violence and criminal accountability. It also illustrates how broader constitutional developments can reshape individual sentences long after a trial concludes. Debates about his culpability and mental state have persisted, raising ongoing questions about the standards for criminal responsibility. At the same time, the case is frequently cited in discussions about the fairness and consistency of the death penalty. It stands as a reminder of how legal systems respond to acts that carry both criminal and profound national consequences. Anthropic has asked a federal court in California to rule in its favor in a copyright lawsuit brought by major music publishers, including Universal Music Group, over the use of song lyrics to train its AI chatbot, Claude. The company argues that its use of copyrighted lyrics qualifies as fair use because it is transformative, meaning the material was used to help the AI understand language rather than reproduce songs. Anthropic claims this kind of use supports innovation across fields like science, business, and education. The publishers, including Concord and ABKCO, disagree and argue that the AI system can generate outputs that resemble or actually compete with their lyrics, potentially harming the market for original works. They originally filed the lawsuit in 2023, alleging that Anthropic copied lyrics from hundreds of songs by well-known artists without permission. The dispute is part of a broader wave of legal challenges against AI companies, including OpenAI, Microsoft, and Meta Platforms, over how training data is used. Anthropic is seeking summary judgment, which would allow it to win the case without a full trial if the judge agrees that its actions were legally protected fair use. The outcome could be highly influential, as courts are currently split on whether AI training on copyrighted material is permissible. The company also emphasizes that copyright law is intended to benefit the public by encouraging innovation, not just to compensate creators. At the center of the case is a key legal question: whether copying large amounts of copyrighted material to train AI systems can be considered transformative use under copyright law. This issue is likely to shape future rulings as similar cases continue to move through the courts. The U.S. Department of Labor has introduced a proposed rule to clarify when multiple employers can be held jointly responsible for wage and hour violations. The rule, titled Joint Employer Status under the Fair Labor Standards Act, Family and Medical Leave Act, and Migrant and Seasonal Agricultural Worker Protection Act, is designed to create a clearer and more consistent standard across federal law. Officials say the goal is to resolve conflicting interpretations among federal courts and make compliance easier for businesses. According to Acting Labor Secretary Keith Sonderling, the proposal aims to both simplify regulations for employers and strengthen protections for workers. The rule would mark the agency's first formal guidance on joint employment since the prior regulation from an earlier administration was rescinded without replacement. Unlike that earlier version, the new proposal would apply to multiple statutes, including the Fair Labor Standards Act and the Family and Medical Leave Act. The department believes a uniform standard will reduce confusion, encourage better business practices, and ensure workers can recover wages or benefits even if one employer fails to pay. Wage and Hour Division Administrator Andrew Rogers emphasized in a story by Law 360 that clearer rules can improve enforcement and reduce litigation. The proposal is currently open for public comment through June 22nd and follows earlier signals that the agency planned to revisit joint employer standards. The U.S. Supreme Court signaled that it may side with the Federal Communications Commission in a dispute over how the agency issues fines to wireless carriers. The case involves major companies like Verizon Communications and AT&T, which argued that the FCC's internal enforcement process violates their constitutional right to a jury trial. The fines stem from findings that the companies failed to properly protect customer location data, resulting in penalties totaling over $100 million. During oral arguments, several justices expressed doubt about the company's claims, suggesting that the FCC's forfeiture orders are not final or binding unless enforced in court. This distinction appeared central, as it implies companies still have the option to challenge the penalties before a judge and jury. Justices, including Amy Coney Barrett and Ketanji Brown Jackson, compared the process to a legal choice: either accept the penalty or contest it through litigation. Some members of the court, however, raised concerns about whether companies may feel pressured to comply due to uncertainty or reputational harm. John Roberts suggested the issue might be more about public perception than a direct legal burden, while Brett Kavanaugh questioned whether the FCC had been fully clear about the non-binding nature of its orders. The dispute comes amid broader scrutiny of federal agency power, especially following a 2024 decision limiting enforcement proceedings at the Securities and Exchange Commission. Despite that precedent, the justices did not appear ready to apply the same reasoning to the FCC's system. Lower courts had previously split on the issue, prompting this Supreme Court review. A final decision is expected by late June and could clarify how far federal agencies can go in using internal processes to impose financial penalties. And with that, and as always, I thank you so much for listening to Minimum Competence, your daily news podcast for lawyers. If you're looking for more than Minimum Competence, links to further reading on all the topics touched on today are in the show notes. And reviews go a long way towards helping new listeners to find our show. If you have a moment, leave a rating or review on your podcast player. We'd sure appreciate it. If you know someone that might be interested in a story we cover, consider sending them the episode. But remember, nothing here should be construed as legal advice, because it is certainly never that. Minimum Competence is available at minimumcomp.com and wherever you get your finely crafted podcasts. If you haven't checked out the website in a while, give it a look. There are complete transcripts and resources for each episode and its corresponding segments, as well as an opportunity to receive new episodes in email, newsletter, form. We'll see you back here tomorrow, and until then, remember, endurance is patience consolidated.